Well, here we go again, I think. You're Dante Caddy?
Yes.
Mr. Caddy, you were previously in court and entered pleas of true to counts 1, 2, 3, and 4 in a motion to revoke your unadjudicated probation. You're on probation for burglary of a habitation. It was a 7-year deferred probation. I have received the updated pre-sentence report, and has everyone had an opportunity to review that report?
Yes, Your Honor.
So there was no agreement reached. Ms. Holmes, you may proceed.
Thank you, Your Honor. I've discussed this MTRP with Mr. Caddy. He has pled true to the violations involving the thefts that occurred at Target location in Port Arthur. Your Honor, Mr. Caddy has also had the opportunity in the past to successfully complete the ISF program. In 2023, he did complete, I believe, both tracks of ISF, which shows that he can make appropriate decisions and follow directions and complete tasks that are given to him. Within the last year, he obviously made bad decisions in which he committed these thefts at the Target location. Mr. Caddy is asking for another opportunity to be continued on probation. We do see that the recommendation from the department, it states that the revocation is recommended. However, if the court elects to continue Mr. Caddy on probation, that he remain off the premises of Target and that this be reviewed in 3 months to monitor any progress. Your Honor, we are asking that he be given that opportunity to show that he can make progress. Since being placed on probation, he has got married. His wife is here today, as well as he does have his mother at this time is very sick and ill, and he does help to take care of members in the household. Your Honor, Mr. Caddy would also like to address the court as to this situation, but we are asking that he be provided the opportunity. We see that he obviously has been afforded an opportunity in the past with ISF, but we believe that if he's given the opportunity again, that he can get steered back on the right track to make more better and more positive decisions going forward with his life. Would you like to address this?
Yeah, yes, ma'am.
Go ahead.
Thank you. I know I made a lot of mistakes, dumb mistakes, but I just ask that you please consider reinstatement. I have a lot of I have a lot of people that, willing to help me with jobs and stuff like that. Like you said, I do have my mom has a lot of stuff going on this evening. Today, she's in surgery today. So I just got a lot on right now.
So, Mr. Caddy, back when you got your original pre-sentence report in 2020, I'm looking back at that, and when they talked to you that day, there's a quotation from you. I'm trying to change my attitude and my drive to do better in life. I want to learn control my anger and patience. I think I will do good. I understand the do's and don'ts. Okay, so that was back in 2020. Then shortly after that, you quit reporting, and you were gone for, I think it was like 2 years maybe. So we get you back after those 2 years in 2022, and you stood in front of me and I'm sure said, give me a chance, I want to do better. And I did. And I extended you, added some time on your probation, and sent you to ISF to help you do those things that you said you wanted to do, make better decisions and do that. Sent you to both tracks of ISF, which most people can't even do. They don't do that anymore. We have to pick one. So you got all the help you needed for drugs, for better decisions. Completed that April 14th, 2023. And then in June of 2024, you pick up well, June and then July, 2 new theft cases after you've already been sent to ISF and given those opportunities after having been given the opportunity the first time to even get on probation, and then after you absconded for 2 years. Ms. Molfino, what's the state's position?
Revocation, Your Honor. I don't have much to add to what the court has already addressed.
You really haven't left me any choice. It makes no sense for me to, we've given you chance after chance, and just saying that you want to do better is, your actions have to be better, and they haven't been. I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years of the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was marked off, though, that it was a plea bargain case, and so now I'm concerned again. Just hold on, don't, just wait a minute, because I want to see. Double check that there's nothing.
It is Judge. I apologize.
Okay,
I'm sorry.
so there was a cap of 4 years. So I'm going to withdraw what I said about the 6 years. I'm going to sentence you to a term of 4 years in the Institutional Division of the Texas Department of Corrections. Mr. Caddy, you can tell from what I've said and what my sentence was that I don't think that's enough. I have the ability to not accept this plea agreement. I'm going to accept it. I don't like it, but I'm going to accept it today. Your attorney did one heck of a job by getting you that deal. I am going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take advantage of this shorter opportunity and get the help you need to get out and make better decisions. All right, you can go back with the bailiff. 1 week? Or do you want to go forward?
Please go forward, Judge.
All right, are you Marissa Tibbetts? And Ms. Tibbetts is on probation for, in 2 cases, for aggravated robbery, 2nd-degree felony. And, is that right? That shouldn't be right. Aggravated robbery would be, was it pled down or something?
Aggravated one? Aggravated, yeah, that's what I thought.
Let me look back here real quick. I just want to make sure what my,
It was, the motions say aggravated robbery.
what does the original paperwork say?
Yes, they were aggravated robberies, Judge.
But they're second or first?
First.
Okay. Give me just a second to look back. I want to make sure. Yeah, the written plea admonishments back from the original plea is marked 1st-degree felony robbery, aggravated robbery. And that's what the commitment and everything was. So this is just a missed typo in the updated pre-sentence report. They're both 1st-degree felony offenses, placed on probation October 29th of 2018, was previously here, entered a plea of not true to a new offense of burglary of a habitation and a curfew violation, and then entered pleas of true to testing positive for methamphetamines and marijuana, and being behind on our court-assessed fees. I've received the updated pre-sentence report. Has everyone had an opportunity to review that report?
Defense says, yes, we do.
And so the burglary of the habitation has been indicted, and so but there's no evidence to put on today with regard to that offense, is that correct?
Just let the court know what's going on. I had sent out letters to officers and to the victim in the case. After a lengthy discussion on the phone with Bo Baden, the victim of that burglary, I determined that we weren't going to need officers because he was going to be able to prove up everything along with the history and the background of the two, because they were married at one point, had separated, and it was him. She had moved out, and it was his door that she came and kicked back in and destroyed a bunch of property. Although in the PSI, I believe she said it was mostly her property that was destroyed. That's not his version of it. We're not going to dismiss this at this point.
Okay, but you don't have evidence with regard to it
I
today?
don't have evidence with regard to it today.
So all I'm doing then is going forward with regard to a positive test for methamphetamine and marijuana on March 18th and being behind on fees. Okay.
And the evidence that she does say she knows that she made a mistake and deeply regrets. I mean, her version of it recounts that an incident occurred on that night.
I don't think that's even enough for a finding of true, just unless she's going to plead true. Okay. So my inclination is this, I mean, we kind of cut to the chase here. Without that allegation at this time, I'm not inclined to revoke her probation. It looks like probably some type of drug treatment. She's even said she would want that and be amenable to that. And so if I'm going to continue her on probation, I think that's probably where we go. And then if the case moves forward, well, I can't send her anywhere with that case pending.
My thoughts, Your Honor, again, I sound like a broken record up here, but mental health, and there's through MHMR, there's a substance abuse through MHMR. Also, I think residential treatment through Franklin House, they can coordinate through MHMR as well.
Yes,
So,
if the court is inclined to send her to special needs safety,
I can't
and she has a
with,
pending-
I would be willing to dismiss the burglary of habitation. We do have a non-prosecution affidavit from the complaining witness.
I mean, that's what my notes are, I'm inclined, I think, just based on the nature of these underlying offenses, then I would think the special needs safety gets us everywhere we need to be, potentially, especially if the other case is going to go away.
She said ISF.
No, if there's mental health issues, it's going to be special needs safety. I think that addresses both issues, and that's the only way I'm going to go along with any agreement like that.
And then the burden of the have is dismissed. If you want to do that. Otherwise,
I mean, I can do it anyway.
yeah, I understand, Your Honor, but the problem would be that him dismissing the.
Right.
burden of the have.
But if I'm going to do that, it sounds like you're probably satisfied anyway.
Okay, so
All right, so here's what I'm going to do. I'm going to find, Ms. Tibbetts, that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations, but I'm not going to do that today. You are being given the opportunity. This is your second opportunity because your first one was, these were caps. When I first put you on probation back in 18, it was actually unagreed, and I took a chance and placed you on probation. It sounds like, and there are some things in this updated report that you've actually done very well while you're on probation. And so you need to make sure and get everything, any issues with regard to substance abuse, self-medicating because of any mental health issues. We're going to give you all the help you need to get the tools to be successful. And you'll go, I'm going to continue you again on both of these probations, order that you enter and successfully complete the special needs safety program. You'll do that, you'll get out, you'll have help, aftercare, and then you're still on these probations. If you do everything right, take advantage of it, you don't have the felony convictions, and you stay out of prison. If, however, you violate any condition of probation after today, I'm going to look back and wonder what I was thinking, because first I gave you an opportunity when it was a cap. Now I'm giving you an opportunity with some other issues and possible new case. So you're not going to get this opportunity. You will be on zero tolerance when you're back on probation. That means you have to do everything right. Do you understand? If you don't, you will be back in here, and you could be facing going to prison for anywhere between 5 years minimum up to the rest of your life in prison. Do you understand? Right.
Right, and I think that the PSI noted that she was up to date on her fees.
Yeah, I mean, there's some good things in here, and we got to get the rest of this, the issues taken care of, so that you won't make bad decisions and get yourself back in here like you did this time, okay? You can go back with the bailiff, and I'll sign the dismissal when it comes through. And that assault is from September 27th of 2024, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen? You're a U.S. citizen.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Stewart is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser included offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. It's coming. My computer's getting tired too. All right, good luck to you, sir. You can go back with the bailiff. For 23-1559, give me just a second, please. All right, so on probation for the state jail felony offense of theft of a firearm, placed on probation March 11th of 2024. There's a second amended motion to revoke unadjudicated probation that's been filed with allegations from not reporting, not doing community service, using alcohol, arrested for assault in Harris County, failing to report for an administrative hearing, out past curfew, another arrest for possession of a marijuana, June 18th of this 2025, arrested for unlawful carrying a weapon, possession of marijuana, again, out past curfew. And so it looks like we already had in April a motion for me to set the bond, which I did, set a bond in this case at $50,000. And required that there be a GPS, remain in Jefferson County, and no contact with the complaining witness in the Harris County assault. Typically, I don't entertain second motions for bond unless there's some new information or evidence. Ms. Holmes?
Well, Your Honor, was requested by the family to request a reduction. I believe his bond was raised at a time, I don't know if it was an initial or designation docket, I wasn't present when the bond was raised to $200,000, so I'm not sure of the circumstances surrounding it going up to $200,000. Based on my conversations with Mr. Zarate Jones, he was tested in court. He tested negative for any substances, but I believe it was because of the arrest in June that prompted the increase to $200,000. I did check with the district attorney's office. There has not been any cases received at this point. from the district attorney's office. And we've also been in contact with Harris County. It's our understanding that that case in Harris County will be dismissed. That's my understanding. He does have an attorney in Harris County that is working on that. But I do believe that the 200,000 is maybe a bit.
Well, it's 50. I reduced it to 50.
No, right now it's 200,000.
That's my understanding as well.
Yeah.
So after I reduced it, no, hold on.
He
After April, I did something else. Is that what?
Yes, I believe, because he was
Sorry.
arrested for the possession.
Arrested again
Yes.
after I
Yes.
did that.
Yes, and I believe he was taken into custody when he came to court in June, I guess.
Yes.
Yes, I apologize, that's my fault.
The cases, though, have not been dismissed yet in Harris County. Is that
No,
correct?
the assault is still pending. Correct.
And
That's
what
just
if-
what I've been told. And the case here, the possession and UCW has not been received at the district attorney's office. They haven't been sent over from the agency.
Have you checked on that? I know the marijuana, I understand if there's some lab issues, but with regard to the UCW,
I haven't checked on that, Judge.
okay, so here's what I'm going to do. I want to know the status of that. Obviously, that's what causes me the most concern, probably about, well, that and the assault, but the fact that I gave a probation, I gave a bond, and then there was an arrest for both of these things after that gives me, obviously, that's why the bond went up. I'm not going to reduce the bond today, but I am going to ask Mr. Coleman if you could please find out the status of that UCW, if it's going to be filed. If it's not, I'm going to reset this for 2 weeks. And if, and the motion, and the marijuana as well, but more so that UCW and what the status is and what the anticipated, if y'all are going to move forward on that, because that makes obviously the biggest difference for me.
Yes, Judge.
And so what I'll do is I'm going to hold the motion. I'm not going to require you to file another one. I'm not going to deny it today. I'm just going to hold it for 2 weeks. I want more information on that UCW. And also, if you can find out anything you can from Harris County with regard to the status of that assault, if there's court dates, if there's dismissal or whatever, then we'll see where we are.
When he went into custody, he missed that court date, so Harris County issued a warrant.
Right.
So I think there's no court date pending at this
Just
point. because
until they
it's a
get on.
warrant.
Okay.
Yes.
So maybe you can just see what the status of that assault is. Okay? We'll see you back in 2 weeks.
Okay.
Thank you.
Sorry, Judge, that I missed the
Let's see, Sheena Harmon, Mr. Kim. Let me look at that.
You want me to print the?
No. Do you see,
We could enter pleas to administrative.
well, there's a first amended that was filed. I don't see it, though. I see order for first amended. When did you file it?
Filed on the 17th, Joe.
Oh, it just says motion to revoke. It doesn't say first amended.
Is it on the 17th?
On July 17th, it says motion to revoke community supervision. I think that should be first amended. I don't know who names that. That's your office, I think, that names it.
No, I filed it though with the name on
It
it.
doesn't say,
They
it's
sent
not,
me a receipt that said,
that's just the regular motion.
apologize.
It looks like somehow in the system, the same original motion
Comes up.
again under that. So apparently, Mr. Kimler, there's been a first amended motion to revoke Ms. Tebow's probation. I don't
Waiver 10 days, Your Honor.
Well, I don't see it.
Well, we just
I would want to go ahead and enter pleas to administrative violations and then ask for a bond pending a disposition sentencing hearing.
Here's a first amendment in one of the cases. So did you file it in both?
I did it.
Okay, I've got it in one, so I can at least get
Right.
there. Okay, so,
Same.
Ms. Tebow, would you please raise your right hand the best you can? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. Ms. Tebow, I have in cause number 22-39100 and 22.
The judge ultimately finds the probation violations true and sentences Dante to prison, but then something unexpected happens. She discovers there was a 4-year cap on the agreement, so she withdraws the 6-year sentence and changes it to 4 years. Even then, the judge makes her position crystal clear. She believes Dante's attorney did an excellent job getting him that deal, and she hopes he uses this shorter opportunity to turn his life around. The message is powerful. When the court gives you a second chance, you have to prove you
And
deserve
at
it.
22-39101, first amended motions to revoke your community supervision. These show that you were placed on probation in 39101. I need a copy of the one from 39100 somehow.
Yes, I have, it's the actual motion.
The first amended motion.
Yes, ma'am.
On-
I'll print it right now.
On 100, you have it? Okay, I didn't see it. If you'll print that one.
Wait, hold on. I'm saying that, I'm looking at the order.
Yeah, there's the order, but the motion is the
It's
same.
all administrative.
Well, there's a.
That's what he
no
filed on the
offense.
17, and then there's not another one.
In the other case, there's a first amended, and so, yeah, I've got that one. But I'm sure it's the same. Do you have a copy of the 10001, Mr.
I don't, Your Honor, but I can have my Irish bring it down.
I need the date. Oh, I can figure it out this way. Let me see what I just printed, please, ma'am. And I need y'all to go back and work on, the 100 wasn't filed properly. Yeah,
Fix it.
but I can figure it out from here, I think.
Sorry, Joe.
No, it's not you. Don't be sorry for something that's not your fault.
That's mine. Didn't take it right.
Okay, this gives me at least this information. So, placed on probation on the same date, May 23rd of 2022, for the offenses of failure to comply with sex offender registration requirements. Both of these have, it looks like you were placed on probation, and your punishment was 2 years in the institutional division, and that was probated for 5 years. Is that correct? In each of those cases? So that means even with the violation, the worst we can do is 2 years? Wow, okay. The motions allege that you violated your probation in count 1 by failing to report to the probation department since January 27th of 2025. And is that true or not true?
Not true.
So you've reported since January 27th of 2025? Here's the thing, Mr. Kimler, hold on. She's under oath, so don't tell her how to plea. So you need to, if it's true, it's true. If it's not true, it's not true.
I don't think she doesn't know.
All right.
I don't know the dates.
Okay.
So it would be,
So count 2 alleges that you've failed to pay your court-assessed fees as directed. As of April 29th of 2025, you are $2,430 in arrears, and cause number 22-39101, and the same amount in the other case as well. And is that true or not true?
Yes, ma'am.
Is it true or not true? Count 1 under the first amended section. Oh my gosh, look at this motion.
I got it thrown, saying
All right.
it needed to be filed, and I apologize, so I filed it quick up.
So would the state like to amend both of those motions to make that 3 and 4 instead of
Yes.
1 and 7?
Yes, sir.
Any objection to that?
what is the full
It's
amendment?
just the
Your Honor?
number.
Oh,
No,
the
it's
number,
the
just number
number.
sequence. No objection.
That's my state's fault.
Count 3 in each case alleges that you were arrested for the offense of petite theft and obstruction by a disguised person on June 29th, 2025 in Putnam County, Florida. And is that true or not true?
Your Honor, I would object to that because an arrest in itself isn't a violation. If the allegation is she was out of county, that would be different, but an arrest isn't a violation of probation.
All right, I'll just put not true for 3 on both cases. Count 4 alleges that you failed to remain in the following location, Jefferson County, Texas, in that you were in Putnam County, Florida, on or about June 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2 and 4 in each case freely and voluntarily?
Yes, ma'am.
And because those 2 counts are actually true.
Yes,
All right, I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to revoke your probation. However, I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated pre-sentence report.